Hi, this is Scott Pierce. Today's seminar is all about death and greed. In other words, we're going to be covering the law of wills and trusts. This is a straightforward subject. It also happens to be one of the very few subjects where a little bit of knowledge of California law is specifically required. We'll have a look at the California variations as we make our way through this subject. The good news is most of the law that we're being tested on here is national law. This is not very complicated and it isn't very difficult. There are a few aspects that are somewhat technical, and of course we've got to keep track of the family tree more often than not in these fact patterns. But basically we're dealing with fairly straightforward material that is intuitively easy to organize and typically fairly straightforward in terms of the questions we're being asked. It's worth knowing up front, at least keeping aware of the fact up front, that wills and trusts easily can be crossed over into the law of real property, where we have a testator or a settlor who is conveying a partial interest or a future interest in real estate. Also, the law of wills and trusts often is connected to the law of community property. And again, we get a chance to have a look at fiduciary liability issues, particularly with regard to trustee conduct in trusts questions. So we get a nice look at the downside of human nature in these problems. We've often got squabbling people who all want as big a piece of the pie as they can get. And our job, more often than not, is explaining who gets what. So you'll notice that I have separate approaches for wills and for trusts. And I think that's useful, but basically this is all one big body of law, and often it is tested exactly that way. So let's begin by considering wills. With regard to any will, either a formally witnessed will or a holographic will, basically what we need to consider are three ideas: capacity, intent, and formalities. So we begin with capacity, and the quick bottom line about capacity is one can be incapable of entering into a valid contract and still be sufficiently competent to create a valid will. The standard of competence is a lot lower for wills than it is for contracts. But the basic idea is you've got to be 18 at the time the will is executed, and you've got to be of sound mind. And you don't have to be that sound. But certainly, if you are impaired or insane, you're not going to be able to create a valid will. So that's it for capacity. It's pretty straightforward. Remember the bright line rule about being 18. Next, intent. And here, intent is, again, fairly generously defined. The testator has to know the nature of his or her bounty and the natural objects of his or her affections. But here in intent, there are issues that are commonly tested and that we're going to have a careful look at. Undue influence, fraud, and mistake are the big ones. Also, the idea of sham and conditional wills. We'll have a look at every one of these issues, at least to some extent. They all are testable, and they've all been tested in the not-too-distant past. Then, finally, we get to formalities. And here, really what we're talking about are the formalities for a witnessed will. And we'll see each one of the details tested, and fortunately, there aren't too many of those details. And also, these details are pretty easy to understand. So, a quick little sidebar. Many of my students are non-California trained attorneys, and others who have not studied local law. In my judgment, the best way to learn the California law, especially for wills and trusts and community property, is by doing a lot of practice essay questions. The examiners know which California variations are important, and they tend to test them repeatedly. So, one variation in California is holographic wills are valid in California. In a lot of other states across the country, they are not, notably New York State. But here in California, a holographic will is admissible to probate. And we will have a look at holographic wills and codicils. Interestingly, we can have a witnessed will which fails because of some problem with the formalities, but then later on, the testator can scribble on this failed formally witnessed will, and that scribbling might serve as a holographic codicil which could serve to republish the earlier failed document. So we've got to be very careful at looking at the chain of custody issues, as it were, with regard to the various documents. A document may begin its career as an invalid, legally ineffective document, and it may end up being admitted to probate. So that's really it for formalities. We will see that there are maybe a couple of other little issues available, but we're going to have a look at all of them. The next broad category of issues in wills and trust essays are those involving revocation and revival. And here we do have a little bit of technical detail to get into, and we will see this detail played out in a couple of the essays that we'll have a look at. So we begin our consideration of revocation and revival by first examining the cluster of issues that deal with revocation by operation of law. Here, by far the most commonly tested material is stuff about omitted spouses and forgotten or omitted children. These issues are tested over and over again, and if you don't know anything about it going in, this is hard material. But you'll see, there isn't a great deal of it, and it does make intuitive sense. None of this stuff is crazy, at least in my way of thinking. So, if we begin with revocation by operation of law, the next step is revocation by written instrument, either express or implied. So, we could have will number 1 written, say, in the year 2000, and then a second will written in the year 2002. Even if the 2002 will is silent about revocation, because it is later in time, it will have the effect of revoking the earlier will. And it also obviously could be the case that the later in time will could have an express revocation clause in it. That would take out all possible ambiguity. But remember, on the essays, our job is principally to spot the issues and then to break those issues into elements and, most importantly, explain the facts and how the law would interpret the facts and lead to a conclusion which is a direct answer to the call of the question. Revocation by physical act actually turns out to be a somewhat more complicated issue than you might think, as we will see fairly early on in this seminar. Next, revival of previously revoked wills. Here, you'll see I list 3 typical ways that revoked wills can be revived, and then I mention dependent relative revocation. Just about everybody's least favorite topic in the area of wills and trusts. Let me give you the Schlockmeister approach, the glib familiarity approach to dependent relative revocation. Remember the situation in which DRR arises. We've got 2 wills, will number 1 in time and will number 2 in time. And there's something wrong with will number 2. Either it is invalid for some reason, or it has been lost, or something else is wrong with will number 2. The issue is, can will number 1 be brought back into existence and admitted to probate? Can we revive will number 1? And the quick bottom line is, it depends. And the way we examine the facts is this. We look at the situation and we ask ourselves, if the testator were here to guide us, would the testator prefer to have the earlier will revived or to have his or her estate passed by intestacy? And so the way we do the analysis is we compare will number 1 and will number 2 with the result from intestacy. If the result of reviving will number 1 is closer to will number 2 than intestacy would be, probably we will allow DRR to revive will number 1. I sort of feel I should pause for a moment to allow everybody who really knows something about this law a chance to stop laughing. All right, I admit I have really truncated DRR and stripped it of most of its intellectual content, not to mention a fair amount of case law on the topic. But for bar exam purposes, we just have to be able to have some idea about what DRR is, figure out when it would be appropriate to at least mention it, and then not embarrass ourselves too badly. Now, we pause to salute academic excellence. Okay, so now we move on to distribution. This is where the real action is in wills and trust questions. Often we have a laundry list of beneficiaries, and the real question is, who gets what? And here we deal with changes in property. You'll see the ademption and satisfaction issues, etc., and changes in people. Here, the California lapse and anti-lapse statute is very common game, and it also is somewhat tricky unless you know it fairly well. So, between the two of us, we'll get to know this material very well and soon. Next, we consider issues of debts and claims and the related concepts of abatement and exoneration, and then we get to intestate succession, a topic which often leads off academic considerations of wills and trusts. Here, we need to be aware of the different levels, the 4 levels of intestate succession, and the distinction between per capita and per stirps intestate succession distribution methods. Again, it's fairly tricky, and again, it's commonly tested, so you really do need to have some real understanding of it. Okay, that's it for the law of wills. It's fairly straightforward, not that different from the national norm, and the California variations are not hard to master. So, next we turn to the law of trusts. This material is even more simple, and the California law is quite mainstream with regard to trusts. So, again, our approach will parallel the one that we take in wills. If the first consideration we had in wills is establishing the validity of the will that we are trying to admit to probate, then the first step of trusts is establishing the validity of an express trust. And here we need intent, an identifiable corpus, beneficiaries, a trust purpose, and the mechanics of creating the trust have to be correct. So obviously we need a trustee and we need a writing. And you'll see that these are straightforward issues. They are not tested in subtle ways, and it's pretty easy to do well if you have an organized and, of course, a fact-specific method of analysis. Next, we turn to administration, and here's where the law of trusts most commonly crosses over to remedies, because the administration of a trust involves fiduciary duties. And here, as everywhere else on the bar exam, anytime you've got a fiduciary, there's a pretty good chance you're going to see some self-dealing or some bad business judgment being applied by that trustee to assets that are under the trustee's control. So, under administration, we consider the scope of the trustee's powers, either express or implied. We consider the trustee's duties. Basically, they've got a duty to administer and to act as a reasonable business person in so doing. And they've got a duty of loyalty. You'll notice remedies actually makes it into my approach at this point. We have remedies available to beneficiaries, and remember that the trustee may well face personal liability for breaches of these duties. Next, we consider third-party issues relating to trusts. Here, this material inherently crosses over to the law of contracts and the law of torts. Here again, we are focusing on the liability of the trustee and also the liability of the trust. Sometimes we also consider the possible liability of third parties to the trust itself. And this relates to fiduciary obligations to keep the books and to make the books available for an independent audit when necessary. So, next we consider the cluster of issues relating to the transfer of interest by the beneficiary. We will focus on the terms of the trust to see the extent to which a beneficiary actually has any right to transfer his or her interest. Next, we consider modification issues, modification either by the settlor, the trustee, or the beneficiaries, and we consider the termination of the trust. Next, a large cluster of issues called charitable trust issues. Here, mostly we're dealing with establishing a charitable purpose. More often than not, that charitable purpose is thwarted or frustrated by circumstances that are really out of everybody's control. And then the issue becomes one of cypre. Did the settlor have a general charitable intent or not? Also, the issue of the rule against perpetuities arises sometimes here in charitable trusts, and you will be a little bit more pleased with it here than you are in real property. It's a little harder to leave out, and it's easier to resolve here. And finally, we have an issue of trusts that are created by operation of law. And here we have a direct crossover into remedies. Here we're dealing with remedies of resulting trusts and constructive trusts. So that's the lay of the land for wills and trusts. Basically, this is another way that the examiners have of testing our knowledge of property, torts, contracts, remedies, and fiduciary duties, in addition to the law of wills and trusts.